Let me tell you the shocking obvious truth you have to know. Contract law can be quite intimidating for beginners, especially if you are not understand the secrets and the true principles of how law of contract works. Do you know that under the law of contracts, counter offer is a valid offer, but it cannot be regarded as a true valid mode of acceptance, or counter offer cannot be seen as a true valid means of acceptance. This is basically what we are going to consider in this video, and at the end of this video, believe me, you will be in a better state to truly understand and appreciate what counter offer means, as well as the valid mode upon which acceptance could be made, and also how counter offer can vitiate a true means of acceptance. So without wasting much of your time, let's delve into this video. But if this is the first time you are coming across to this channel, King's Advocate Network, I encourage you to subscribe so that you'll be able to receive all the weekly video we post here. We share legal updates, we share law tutorials. Subscribe so that you'll be notified whenever we post a video here, which happens every single week. Now, for the better understanding of every single thing we are going to say in this video, let us start by defining what a counter offer is. Reduced to its simplest term, let us know what a counter offer is. A counter offer is a statement by the offeree which has the legal effect of rejecting the offer and of proposing new offer to the offerer. It puts to an end the previous offer of the initial offerer. The effect of this definition, which we just saw now, has made us to understand one thing, that if you, Mr. A or Mr. Stanley, has made an offer to Mrs. Wagner, and Mrs. Wagner, instead of accepting it wholeheartedly, tries to vitiate or tries to vary or trying to change the terms you, the offerer, made ab initio, that offer becomes what we know as counter offer. And without wasting much of our time, we go to the locus classicus case that illustrates what counter offer means. It was that case that established the principles of what we now call counter offer, the case of Hyde and Wrench. It's an interesting case which definitely all students of law of contract must know. It was a case decided in a common law jurisdiction in England. So in that very case, Wrench, the defendant, made an offer to Hyde to sell his farm for £1,000. Then Hyde, on the other hand, instead of accepting it unequivocally, as we pointed out last week on our previous video, which has to do with acceptance, I encourage you, after watching this video, go to our playlist to check out the video, other video that has to. We have made 2 existing videos that talks about offer and talks about acceptance, without counting the other video we have made on element and definitions of contract. I encourage you to go and check out that video. As we are saying concerning this very case before us, Hyde, instead of accepting unequivocally, vitiated or varies the offer which has been proposed by Wrench. So according to him, he said that he wants to buy the farm, but he can't make up to that very amount, which is £1,000 as proposed by Wrench. So Hyde was of the view that he can only afford to buy this farm for £950. Hyde's response to the offer made to him by Wrench then amounted to what we called counter offer. Look at what he did. Wrench proposed £1,000 for the sale of his farm. Then Hyde, instead of accepting unequivocally, wholeheartedly, varies the offer, changes the terms of the offer by saying that he cannot actually afford that amount, that he wished to pay £950, which is contrary to the £1,000 offered to him ab initio by Wrench. I mean ab initio originally by Wrench. Now, when the counter offer through the writing get to Wrench, the defendant, Wrench said that he's not going to sell for that £950, that he's not accepting, that it's not good for him, and he's not selling. The contract is therefore, I'm not going with this very contract. Later on, Hyde also, maybe after giving it a thought, a deep thought, decided to buy the farm for £1,000. Remember, £1,000 was the original offer made by who? Wrench, the defendant. When the letter gets to Wrench again, Wrench then changes his mind. I'm not selling again. I'm not even going to sell you £1,000 again. I'm done. I don't know who annoyed Wrench, or whether the stress annoyed Wrench, I don't know. But Wrench stated that he's not selling again. Then Hyde went to the court to sue Wrench for breach of contract. According to Hyde, the argument of Hyde was that Wrench has made an offer to him to sell his farm for £1,000. So he don't see any reason why in this case now Wrench will go back to his word. Remember, the law frowns at those who appropriate and reprobate at the same time. And also remember the Latin mass, the peccator sui servanda. Men are to honor their words. In this case now, Hyde was of the view that in line with peccator sui servanda, men must honor their words. This man Wrench ought to honor his agreement of proposing to sell for me this farm for £1,000. Now I have accepted this farm. I have accepted to buy this farm. Why is he changing his mind suddenly? There is a contract. I have made my acceptance. Therefore, I'm going to court. When they reached to the court, the question before the court was there a valid offer? Was there a valid acceptance? Was there a valid contract? The court in this case was faced with a dicey situation of actually examining whether there was a valid contract between Hyde and Wrench. Hyde having accepted to go with the original offer offered to him by Wrench. This was the question before the court. So the court in that case held that a counter offer destroys the original offer, meaning the offeree cannot later accept the original terms unless the offeror renews the offer. I will take my words again. The court in this very case of Hyde vs. Wrench held that a counter offer destroys the original offer, meaning that the offeree cannot later accept the original terms unless the offeror renews the offer. I hope someone understands this principle enunciated in the case of Hyde vs. Wrench. The court, after examining the whole incident, after examining the whole fact of the case, held that the counter offer, because I told you that what Hyde succeeded in making in this case is not acceptance, but a counter offer. According to the court was of the view that if the offeror has made an offer to the offeree means the person that received the offer, which is bound either to accept or not to accept. In this case, the offeree must accept everything that is stated in an offer unequivocally. That is wholeheartedly. It is not something like I told you in my previous video acceptance. Okechukwu promised to marry Fadilat. Fadilat, instead of accepting the marriage proposal by Okechukwu, decided to say that you have to send me abroad for me to finish my LLB before I will consider marrying you. Otherwise, I will not marry you. In this case now, what Fadilat has made to Okechukwu is what we call counter offer. She has not accepted that offer, and because she has not accepted it, it is no longer an acceptance. It is no longer binding, but it is now dependent on Okechukwu to make an acceptance. Okechukwu is no longer the offerer but an offeree, because Fadilat has varied the offer by making additional proposal. And the court has always held that for an offer to be valid, for an acceptance to be valid, it must mirror the terms. It must mirror wholeheartedly the terms that is conveyed by the offerer. Any other change to that effect that is inconsistent with the terms of the offerer is null and void to the extent of that very inconsistency. Hope someone is getting my point. If you're actually getting my point, hit that subscribe button and turn the notification so that next week when I'm making another video, it will pop on your phone and you'll be able to check it out. However, give me a like, very important. Then I will give you another local classical case to watch out for, where the court will stress this point of offer, counter offer, and acceptance. In the case of Bilante International Limited and the Nigeria Deposit Insurance Development Company, a case decided in 2011. In that case, Padegoke JSC stated something very important. According to the learned judge, he stated that for an offer to be a valid one and for an acceptance to be a valid one, to the effect of a valid offer, the offeree must accept wholeheartedly and unquantified and unqualified all the whole terms that is conveyed to him by the offerer. Hope you get that point. So if I made an offer to you, instead of you accepting it, you vary it even to a little way. That amount to counter offer and can never be regarded by as acceptance. Acceptance means yes, I accept. And again, there is one notable argument made in that case of Hyde and Wrench, which it will not be good on my own part if I didn't tell you. The argument of the defendant, Hyde, was that he actually didn't reject the entire offer conveyed to him by the defendant, Wrench, but rather he only varies the price. He accepted actually to buy that farm, but the problem now is that he only was not comfortable with the price. And he proposed, please sell 950 for me. This is something we do regularly in a normal Agege market or a normal Onitsha market or all this kind of market. This is normally what we do here in the Alaba market. You will go, I want to buy this, I want to buy that, and you people begin to exchange, begin to negotiate. This is our negotiation. So my man Hyde was like, if actually I have actually wanted to buy this farm. Now, is it because of ordinarily that I vary the price that makes the court to hold that actually there is no offer in this case and there is no acceptance in this case, or what exactly? That was his argument. But the court was like, that is when the court established the principle I'm going to tell you now, the mirror effect principle. The mirror effect principle simply means that the offer The offeree, the acceptance, must mirror everything that is conveyed by the offerer. Any other thing, to the extent of its inconsistency, is null and void as far as element of contract, offer, and acceptance is concerned. You will rather accept everything. If the court has accepted the argument that it was only the change in price, and therefore this would not nullify the original offer made to Hyde, the decision could have been contrary to what I just said. The holding of the court in that very case is that if actually you want to accept, you must accept everything. Any variation has rendered the original offer not valid. So Hyde could not go back to eat his vomit. Hyde could not go back to accept the offer which originally he has rejected. That was the view of the court. What he then made to buy, when he then decided to buy the farm, what he has done in law is counter offer, and counter offer is no longer an acceptance. That's why I say in the beginning of this video, are you aware that counter offer is a valid offer but not a valid mode of acceptance? Have you seen what I said? That is a preamble I gave to that in this beginning of this video. Now I'm trying to tell you that counter offer is a valid offer in its sense, but counter offer cannot be regarded as a true acceptance. If somebody offers to sell a book to you, you vary the price. What you are then making to the person is not an acceptance but a counter offer. That counter offer has become a true offer in this sense. The other person is bound to accept. In this case now, you were the offeree but you have metamorphosed to offerer. And now the other person who was the offerer is now the offeree. It's now left on him to decide to accept or not to accept. I believe this establishes what we are saying. Now I'll proceed to give you two ratio distinction that is established in this case of Hyde and Wrench, and it is very important because it is actually a case that no students should joke with. Now, based on the decision we see in this very case, we have seen that the court actually established the fact that there was no contract between these two parties, Hyde and Wrench, and therefore Hyde cannot maintain an action for the breach of contract, which actually does not exist. When Hyde actually made a counter offer of £950, it automatically rejects the Wrench's original offer of £1,000. This means that the original offer no longer exists and could not be accepted later. So we see that when Hyde made a counter offer of £950, it automatically rejected Wrench's original offer of £1,000. This means that the original offer no longer existed and could not be later accepted. So when there was a variation, the contract is no longer there. What is now there is a counter offer, which my man Wrench still has the option to accept, and which he did rejected before Hyde approached the court. So we have seen that a counter offer is a valid offer, but not a valid means of acceptance, so to say. Now, another thing you have to know is that acceptance must be unequivocal. I stressed this earlier on in my first video on acceptance, as well as the video on element of offer, which offer was involved, as well as the video on offer as element of contract. Also, in my initial video of introduction to contract, I have established this point that an offer, an acceptance, and offer, all of them, the two things must be unequivocal. Any other thing contrary to that is null and void to the extent of its inconsistency, said by the King's Advocate. Yes. Now, the second thing you must also know is that to form a valid contract, the acceptance of an offer must match the terms of the offer without any change. By proposing 950, Hyde did not accept the original offer, but instead made a new one. By that very proposal of 950, he has not accepted any offer. What he has succeeded doing is making a counter offer, which my man, on the other hand, is still bound to accept or not to accept. So this is a very valid point. You have seen it in this video that actually counter offer is a valid offer in law, but acceptance, for acceptance to be a complete one, it must be one that mirrors the terms of an offer. So counter offer is not a mode of acceptance, but it is rather a valid offer, which the offerer, which has metamorphosed or changed to the offeree, is bound to accept or not to accept. And if you wish to check my video on offer as an element of contract, click the link above and you are going to see that video. If you also wish to check all of my video on introduction to contract, click the video above. That two video is going to help you. Remember to subscribe to the King's Advocate, and I'm going to see you next week. Thank you for watching this video.